Nigeria. And interestingly, some of the books that we were studying when I was doing constitutional law included a book entitled, I think, something like Constitutional Law in Nigeria by Professor Benjamin Nobweze. When I look at our laws, our system of laws, it's very, very close to what there was, or there, I believe there still is here. So under the Judicature Act, the courts are mandated to exercise their jurisdiction in accordance, one, with the Constitution, which we have looked at, then two, the statute law, basically acts of parliament, and then thirdly, the substance of the common law, doctrines of equity, and then there is a cutoff date, I believe even in the case of Nigeria, as to when when Nigeria became a protectorate of the British Crown. And then there is also that proviso that the law is to be applied only insofar as the circumstances and the inhabitants permit. And that's one of those very, very gray areas as to which inhabitants, which circumstances, but that is where we find ourselves. So we have the Criminal Procedure Code that sets out the procedure. We have, of course, penal laws, and the most used of them is the Penal Code, but we do have various other laws that deal with specific offenses, anti-money laundering. We have the Anti-Corruption and Economic Crimes Act. We have very many others, including those that deal with matters such as witchcraft. Now, so I would want to turn now a bit to the question of the delays in the courts. And from what I was hearing yesterday, I get the impression that we are living in very, very much the similar circumstances, where there has been endemic delays in the management of criminal cases, and that we are looking for solutions as to how to reduce the delays, both in the period of pre-trial detention, right through to the entire spectrum. And one of the things that Kenya has done is that it has come up with a program which it calls active case management. Active case management. That is a program that Kenya has been able to formulate through the support of the United Nations Office on Drugs and Crime. And on the other hand, the judiciary itself has also had something called the Judiciary Transformation Framework. And under the active case management, under the active case management, the criminal justice sector has, first of all, identified that this working of the working to reduce delays in the criminal justice system cannot be the preserve or the duty only of the judges and magistrates on the one hand, the prosecutor on the second hand, and then the defense. That it has to be a lot more broader based. And this is why yesterday I was asking whether we are having a conversation with ourselves or whether we are in a position then to see how to address the questions of a delay. Now, in the Kenyan situation, we have actually identified no less than about 30 stakeholders in the criminal justice sector who have an input one way or the other, including civil society, including probation and aftercare services, the prison services, the police services, the National Legal Aid Program, etc., who all have a role to play in ensuring that the question of delays is thought through in a way that will then be effective and efficient. And as a starting point, the retired Chief Justice David Maraga set the pace together with a small team as part of the National Council on the Administration of Justice, and some guidelines were promulgated that helped in ensuring that the question of delay was very deliberately addressed. Yesterday, I did talk about, I didn't want to be very unkind to ourselves, because I know that for a long time, in Kenya, for example, we have had a criminal justice system that was essentially on a free fall. That we, the judges and the magistrates will go to work. It's business as usual, and by business as usual, I'm not even talking about the corruption side of business as usual, because that's a big problem. But I'm saying that somebody has that mindset that I am employed, I'm in a job, it's an 8 to 5 job. I just want to see how to drift through the day and in the evening get back home to my children, and at the end of the month get my pay. And the same thing would happen with the lawyers, even us in private practice, where we would be going to court, and we have this mindset of, I know the judge or magistrate is not going to start at 9 o'clock. The time that's normally, the judges and magistrates in Kenya normally start at 9 o'clock. They're supposed to be in office from 8 to 9 when they're going to court. Of course, between 8 and 9, they're doing other work, or they're expected to be doing other work. So we would go, and we know this judge or this magistrate will not come in until 11. So, but because obviously we do not have any indication as to exactly when the judge or magistrate will come, we go to court and we wait. But we go to court not being fully prepared, because we know, after all, nothing will happen. The case will not move on. And we know also that the prosecutor will not be having his or her witnesses and that despite our protestations, when the prosecutor says, I had bonded 3 witnesses, I can't see any of them here, and therefore I'm asking for an adjournment, then they will be given an adjournment as a matter of course. That is where we used to be. Thankfully, we are in a slightly better space today, because with the guidelines on active case management, the judges and magistrates have slowly gotten their mindset being changed. The prosecutors, again, also have gotten their mindset being changed. The defense lawyers, the same thing. And when I say the prosecutors and defense lawyers, I'm including also the victims' representatives. So that there has to be a deliberate effort towards ensuring that cases are, the cases begin and conclude without unreasonable delay. That is the difference between the new constitution and the old constitution. The old constitution was just about hearing the cases within reasonable time. But this other one is a lot more deliberate. A very positive duty to ensure that the beginning and the conclusion without unreasonable delay takes place. So what then happens is this, that with the active case management in criminal cases, we have successfully been able to challenge the judges and magistrates and say, no, the manual on active case management says A, B, C, D, and then they have to give a reasoned ruling, which they know can be appealed. And therefore, they are a lot more careful, because like all of us, we want one day to move from the magistracy to become judges. Once we are judges in the High Court, we want to become judges in the Court of Appeal and eventually in the Supreme Court and so on. So then they are held to a higher standard than they previously were. Of course, together with that, there has to be an environment that is also enabling this change to being deliberate about the reduction of delays. And one of them is the use of the Judicial Service Commission, which is responsible for questions relating to the discipline of judges and magistrates, so that when a judge or magistrate is not up to the task, then you can make the complaint. We hesitate to do so, but then sometimes we're compelled to do so. But when we do that, then because you have very clear guidelines that ought to have been followed and you're able to demonstrate that they were not followed, then action can be taken. And once action is taken against one person, you perhaps transform 100 others. So there is that exponential effect. So the old position, the right to have a trial conducted within reasonable time only identified the resource, which was time, but not the threat. And the threat is really what we need to be very alive to. Now, at the same time, we find, I don't know what kind of period we have for from one mention date to another mention date in case of accused persons who are in custody. How often are they required to go back to court? Because we have this procedure where if there is a mention today, which is supposed to be just a short session to technically reconfirm the physical wellness and well-being of the accused person and any concerns that they might have. These concerns may be medical, they may be that when they were arrested, we have this very interesting situation where normally when you effect an arrest, the accused person, one shoe from the accused person is taken away, so that in the event that he or she, well, to be fair, more often he would like to escape from protective custody, then they will go with only one shoe, and it's easier to identify them if they escape from custody. And so once they're in custody, then they should be able to say, my shoe was taken at the time that I was arrested. I came to court, I pleaded not guilty, I am now in remand, and I still haven't been given my shoe back. And those issues will be addressed. So every 14 days, there is a mention of the case. I do not know, that procedure is there here? It's not there. In the magistrates' courts. Okay. All right. So we have that, and one of the things that has been done, because it's also more, and I say more not only because there are obviously fewer high courts than magistrates' courts, but as a matter of practice, it's a procedure that is used a lot more in the magistrates' courts. But there is absolutely no reason why the date from one mention to the other should be a period of 14 days. It can be much shorter. But in the past, before the active case management guidelines came into use, it would be an accused person comes, and then his name, her name is called out, and even without more, they just told next mention will be on a certain date. And as a result of all these things, one of the things that we have done is that we have also stopped having those mentions conducted in court, but out in the remand prisons, which makes a lot of a difference, because then one is able to make a savings on time, and two, even other people that whose matters might not have been coming on that day would be available to have access to the magistrates to deal with whatever, to give whatever orders may be necessary to ensure that their conditions in prison are being respected. And then obviously that does accelerate or does reduce the time between when they first appeared and when they eventually, when the case eventually was heard. Now, with regard to the judiciary, transformation framework, 4 pillars were identified, and these complement the active case management approach. And one of them was a mode of delivery of justice that would be deliberately people-focused. And as we have seen, that was also the case, or is also the case with active case management. Then transformative leadership supported by an equally transformation-focused organizational culture. Because to me, I think culture is everything. If you go into an organization where everybody is thinking about getting in the morning at whatever time, it doesn't matter, all they need is to be seen at one point or the other and then leave for the day, then you are unlikely to achieve much. And then, of course, that calls for a staff that is professional, in its approach, and professional also in terms of having the professional competence, and also a staff that is motivated. So some of the things we're talking about indirectly over here is the building of capacity, which obviously does have financial implications. And this was identified as a key pillar separately, that there would be provision of adequate financial resources and physical infrastructure. Now, during the administration of President Daniel Arap Moi, the judiciary's budget was completely managed through the exchequer. So what would happen is that the judiciary would be given just a small budget to enable it be seen. But this was controlled in such a way that if the judiciary started looking independent, then funds would be withheld by the executive. But in due course, there was pressure that the judiciary, for it to have functional independence, it had to have financial independence. And right now, what we have is that monies collected by the judiciary in forms of fines and any other levies and grants in aid and so on would normally be accounted for by the judiciary itself, and the judiciary then is able to run its own programs. In Parliament, the other thing is that the allocation for the judiciary is a lot more than what it used to be before, and therefore the capacity has been enhanced. Now, so what we're seeing here is that these approaches call for deliberate and concerted efforts so that all the players in the criminal justice system, and now you can see that the criminal justice system will include even those decision makers, be they in the executive, be they in Parliament. That's the only way that one will be able to address the issues in a holistic manner. So the starting point then becomes the identification of an overriding objective. what we call the oxygen principle because of the double O. So we say O2. So the oxygen principle, and that's something that has been used in every aspect of litigation. So that you, when we're thinking about formulating rules, even in criminal procedure, we ask, what is the overriding objective in civil litigation? We identify it, and then we move along with it. And some of the things now that have been identified, for example, in keeping with the overriding objective, the active case management approach has identified that the two components of the proper administration of criminal justice is to arrive at a just decision and arrive at that decision in an expeditious manner. So it's both qualitative, that's the justice aspect, then quantitative in terms of ensuring that the process begins and concludes without unreasonable delay. And it was identified that when we talk about just and expeditious disposal of criminal cases, we are dealing with, amongst others, the following key and very clear issues. One of them is acquitting the innocent. Another one is convicting the guilty. Another one is dealing with the prosecution and the defense fairly. And on this one, it's very interesting that when I started practicing law in 1989, I found a situation that was extremely hostile to the defense lawyer. I would go to a magistrate's court, and I am waiting for the magistrate to start, but the magistrate is in his or her chambers with a prosecutor. And of course, I was only interested in being in open court with the magistrate and the prosecutor. And I think the naive me thought that the magistrate and the prosecutor being in chambers together, they are both civil servants. That is the way I understood it, that there was nothing so wrong. Until, of course, I got to understand in the course of practice what happens, and sometimes I still think that historically that is why we have the magistrates and judges starting their court at 9 rather than 8 o'clock. Because there is another form of active case management that the prosecutor and the magistrate will be doing. Yes. So that's one of the things that we identified. We've been trying to fight for a situation where, in the same way that the working day is an 8-hour working day, that we have court starting at 8 o'clock, and then going on up to whatever time in the course of the day. Of course, we need to recognize the fact that some time would have to be allocated to the writing of rulings and judgments. But there is a way that it can be done in order to reduce that incidence of too much familiarity between the prosecution and the magistracy, or not so much the judges, but at the magistracy level, at least in Kenya. So that therefore need not be overemphasized. That one, there must be fairness in dealing with the prosecution and the defense. Then also one of the other things was a recognition of the rights of the accused person, particularly those rights granted under the Constitution. And under the Constitution, apart from the fair trial rights that I talked about, there are various other rights. We have the rights of an arrested person. We have the rights of an accused person, which are distinct from the rights of an arrested person. We also have the right to fair administrative action, so that if you're a suspect and there are certain things that are happening at the level of the police station and you are not being treated in an open, credible, expeditious manner, then you have the right to make a complaint to the Commission on Administrative Justice, and action can be taken. There are other institutions. There is what we call the Internal Police Oversight Authority, that, for example, police officers can be reported to. And then again, still, as part of the just and expeditious conclusion of matters, we have the issue of respecting the interests of witnesses and victims by keeping them informed of the progress of the case and protecting the rights of the victim under the law. Then there is the determination of the case efficiently and expeditiously. And some of the things that would come in under the efficient and expeditious determination of the case is the duty of disclosure, so that at the right from the outset and on an actively ongoing basis, whatever information the prosecution is supposed to pass on to the defense should be passed on to the defense. We are in a system in Kenya where there is no corresponding duty of disclosure by the defense, which is quite unlike the International Criminal Court or the international ad hoc tribunals. I have tried to labor in my mind as to whether we should also require the accused person to disclose, not just in the case of alibi. I think that is the only situation where it is generally recognized that if somebody is saying, I was not there when this happened, then they need to indicate right from the outset what the basis of their defense would be. Then some other components of the just and expeditious include dealing with the case in a way that takes into account the gravity of the offense, the complexity of the issues, the severity of the consequences faced by the accused, by the victims, by the witnesses, and everybody else that's affected by the case, and the needs of accused persons who are unrepresented, because when you're dealing with an unrepresented accused person, then there could be delays relating to lack of preparation, because sometimes the level of appreciation of how expeditiously a matter should go might not be very well appreciated by the unrepresented accused person. And also there is a question of remaining alive to the needs of other cases. That this is just one case, there are many others that need to be dealt with, and so on. And then very briefly, I would want to just mention that in the wake of the COVID-19 pandemic, Kenya found itself in a fairly good space because it had harnessed technology to some extent. And I'm saying to some extent because there were many people that understood within the judiciary how to use technology. But then, as I would expect in a lot of jurisdictions, and not just Kenya, I don't know about Nigeria, we found ourselves also with a lot of judges who were not technologically illiterate, but let me bring it to the barest level: computer illiterate. We had a good number of those, and that, of course, is part of the history of our own country, and I believe of very many other countries. When I started practicing, we had basically, I think, the most advanced equipment that we had. Two of them. One of them was a word processor, and the other one was a fax machine. And that fax machine, I remember I was in a law firm that was one of few that had fax machines then. And so on my calling card, I had to ensure that when the calling card went for printing, it showed that we had a fax number. Of course, that meant a lot for a young man who was not married then. Once you give out your calling card and it shows, oh, this person works in a firm that has a fax machine, then it completely boosts your status. But unfortunately, we have had a lot of people, despite a lot of training, both within and outside of the judiciary, that have not been trained or that have been resistant to change. And there is no cure for that, apart from, sorry to say, retiring them. Because I do not want to imagine that in a 21st century, in a 21st century criminal justice sector, we cannot have the drivers of the sector being computer illiterate. We cannot have them not understanding fairly basic applications that mean so much to the lives of their citizens. And so we found ourselves in a good space, as I wind up, in that there were at least people that had already started undertaking this training that then put them in good stead even when COVID-19 came in, and the Kenyan courts had to shut down for a while just to put in place various the infrastructure. And today, at least, we are able to do a lot of our cases, even when we have traveled. I think I will want to leave it at that for now. And I thank you very much for your attention.
It's another round of applause for Mr. Nderitu. Thank you so much, sir. Thank you. Thank you so much. And we are going to get to our second paper now, but before we do that, I have instructions that we need to do some stretches before I introduce the next speaker. So I'm going to be calling on Honourable Justice Eno Isangedighi for the stretches. Please, a round of applause for her as she comes. It's very important we do all these stretches so that we don't lose our muscles.
Ladies and gentlemen, please rise. Head, shoulder, knees and toe, knees and toe. Let's go. Head, shoulder, knees and toe. Una no fit bend. How can you say knees and toe? You say knees and toe. Let's go. Head, shoulder, knees and toe, knees and toe. Head, shoulder, knees and toe, knees and toe. One more time. Head. For the last time. Head, shoulder, knees and toe, knees and toe. It is not yet over. Not yet Uhuru. Now, you are going to spell your name. But you use, this is the time I'm usually happy that I have a very short name, Eno. E-N-O. So, you know the spelling of your name, and you are going to spell your name using your waist. For instance, this is E. That's an E. For N, that is an N. And for an O, so you want to spell your name. If you are Mary Magdalene, spell your name. You are Christopher, spell your name. Take your position. 1, 2, go. Everybody spell your name with your waist. Now, yes, you will spell your name using fast tempo noun. Let's go, very fast. 1, 2, go. On our waist, no feet shake. What is wrong with your waist? We went for a party somewhere in those days, and my friend who went with me sat on the same table with her senior sister, and her senior sister said, why is that person behaving like that? Do you mean at my age, I am 40? I am 40. At that time, I am 40. And I could, even at 40, I mean, how could I do a thing like that? And then immediately the party was over, the senior sister who was there said to her, you see all this nonsense age you're always talking. Why did you tell those people that you are 40? I'm your senior. I had already told them that I'm 34. And everybody knows that I am your senior. Gentlemen, enjoy the rest of the day.
Thank you so much, Milord. Please, another round of applause for that session. At least that got us all stretching. Thank you, thank you, thank you. Those simple exercises are very important for us. So we're going to have the next speaker who is going to be talking to us online. And of course, he's going to be talking to us on the issue of reducing delays, which we are all very familiar with in the administration of criminal justice. The presenter is somebody I like to introduce at all times. He is no other person than Dr. Chief Anthony Idigbe, SAN. He's the senior partner of the firm of Punuka Attorneys and Solicitors, unarguably the best firm in Nigeria, and is described as one of the most experienced and well-rounded lawyers of our time. He is a seasoned legal practitioner with over 39 years experience in advocacy, insolvency, business restructuring, arbitration, dispute resolution, privatization, capital markets, mergers and acquisition, aviation law, and telecommunication law. Chief Anthony Idigbe has advised clients on several complex transactions and has earned a reputation for being a thoroughbred legal practitioner. He was admitted to practice law in Ontario, Canada in 2016. Chief Anthony Idigbe is a president of the affiliate firm of Punuka Attorneys and Solicitors, Punuka Consulting Incorporated, based in Toronto, Canada. He was elevated to the rank of senior advocate in the year 2000 and was appointed a notary public in 1989. He holds a GP-LLM postgraduate degree from the University of Toronto and an LLM from Robert Gordon University, Aberdeen, Scotland in 2012, and many other degrees. And I'm sure by the next time I'm introducing him, maybe this time next year, you would know that he has another degree. He's somebody that doesn't get tired of going to school. He's a member of the Board of Trustees, Canadian Association of Nigerian Lawyers, a fellow of INSOL International, Chartered Institute of Arbitrators, London, Business Recovery and Insolvency Practitioners Association of Nigeria, and International Bar Association. He's also a member of several national and international bodies. Someone you're going to listen to now he's already online. Hello, can you hear us, sir? Please, a round of applause as we welcome Chief Anthony Idigbe for his presentation. Thank you so much. Please, another round of applause for Chief Idigbe. Thank you, sir, for giving us that exposition. We can actually see that honest and assessment of the laws. It's not just about the laws. Because every time we just happen, oh, we need a new law, we need a change, we need a reform in the law. But we see that most of the work that needs to be done is actually in the implementation. And I know that Akwa Ibom is on the right track and will get it right. So we want to have questions right now, and we also had some questions outstanding from yesterday. The ushers are moving around. If you have question, please can we raise your hand so they can come to you? If you have question. Okay. Okay, there's a hand raised here. Milord is raising her hand in that table. Please, could you raise your hand so they can see you? So behind the table, behind. Okay. Okay. She has the microphone now. Please go ahead, Milord. The first, of course, you can, two of them you can ask at this time, yes. But there's a hand raised already. She's already with microphone at the back. Oh, okay. Okay, she said you can go ahead, my lord. Please go ahead, my lord. Please help her with the microphone. I think it's switched off.
You said you have about 36 stakeholders in justice sector delivery in Kenya. Could you please give us some of the examples of the stakeholders, because there seem to be a lot compared to what I think we have over here. Maybe we can learn one or two things from them. Thank you.
Next question too, so that we can respond. We'll take 3 questions and then respond. Please, can you?
Good morning, everyone. My name is Chief Magistrate Helen Omana. My question is actually from yesterday's presentation, and it has also dovetailed into what the second presenter talked about. It has to do with the presentation of yesterday in respect of Restorative Justice Center. The presenter actually gave an overview of it. I actually wanted him to tell us how Restorative Justice Center is operational in Lagos State. I've seen him here. I think he's here.
Yes, Mr. Kimbola is here.
Yes, Mr. Kimbola is here, yes. How it is operational in Lagos State, because the second presenter has told us that it is actually not working. So I want to know how it can be used in Akwa Ibom State. My key interest is on ADR, how we can, marry it together to help in the congestion of cases at the High Court, Magistrate Courts. Thank you very much.
Okay, with due respect, their lordships here present, the Honourable Chief Judge, very ably represented, and my colleagues. My question actually goes to, my name is Theresa Ntong. My question goes to our learned friend from Lagos State, who made a presentation yesterday also. Please, sir, I'd like you to speak into the practicality of Section 32 of the ACJL. We are magistrates, that is for me and my colleagues, and we see that the section is making a provision which we had even known earlier, recognizing the right of suspects to be granted bail within a specified time. And now we are told that only lawyers, police lawyers, or from the Attorney General's office can sign charge sheets and indeed prosecute. We have a scenario in my jurisdiction where I used to have so many arraignments Suddenly I noticed that they don't come any longer. And I go talking with the DPO, and he says that he sent all the matters to the legal department. We don't see them. It appears that they grant administrative bail, and the suspects don't just come to court. And so I want you to please guide us on what steps to take in this regard. Yesterday, I know my colleague had alluded to the police being allowed, that is, non-lawyer police, being allowed to arraign, and thereafter the court makes an order for the file to be transmitted to the office of the DPP or the Ministry of Justice within that jurisdiction. Can we have that? Is that our understanding? Is that the practice we should go and operate? Or do we wait until the charge sheet is properly signed by a law officer who is a policeman or thereabouts? Secondly, sir, I have another troubling scenario in my court. Before the onset of the ACJL, there is this 2018 matter. It began de novo before me in 2020. The prosecution had fielded 4 witnesses. Again, before the ACJL, the defense had fielded 3 witnesses. DW3 was the last defense witness. And on that day, the prosecution comes up and says, "Your Worship, may I take a date to enable me cross-examine?" That was in May. The matter was adjourned to June 2022. And by that time, the ACJL had set in. They come before me, and the police, the ex-wild police prosecutor, informs the court, "Your Worship, I have transmitted all the files premised on the signal that the legal department gave. I've transmitted all the files to the legal department. And this complainant is bitter. He feels he has been in court since 2018. And just when he was seeing the end of his case, he is told to wait for the file again to be taken over by a lawyer. All that remains for that file was the cross-examination of the last defense witness. I think I stated that case actually to the Chief Judge, the Honourable Chief Judge of our state. I stated that case, and I was given assurance that such matters will be handled here. I know that my colleagues are having similar experiences, so would like you to please speak into this issue so that we can go back and have, a sense of direction. Thank you very much.
Okay, we'll take these questions now. Please, can you give the facilitators? Chief Idigbe will also seek your comment on them once the facilitator is speaking. So
Yes, thank you, Honorable Judge. I was just trying to put down the various stakeholders and what I have come up with so far. The judiciary, the Law Society of Kenya, in our situation over here, there would be both statutory and I believe non-statutory bar associations or associations of lawyers. There is the National Police Service. There is the Office of the Director of Public Prosecutions. There would be the Kenya Prison Service. In our situation here, again, the prison service. There is the Kenya, again, I'm just talking about ours, but even here, I'm sure there is a Law Reform Commission. There is, in our country, a probation and aftercare service. There is the Department of Child Service. There is the Independent Police Oversight Authority. There is the Commission on Administrative Justice. There is the National Human Rights Institution, which in Kenya is known as the Kenya National Commission on Human Rights. Then there would be generally the NGOs that are involved in the field of human rights, and in particular criminal justice. There are those that would be involved in child rights. There would be the National Legal Aid Service. There is the National Crime Research Center. There would be the Witness Protection Agency, Victim Protection. There would be the Kenya Defense Forces. In our situation, basically, we're looking at offenses that are committed and are triable by the court. There would be the Ministry of Health, which the department that would be responsible for psychiatric services. There would be the Council of Governors Secretariat, because we have two-tier system of government. We have the national government and we have a county government system, not quite federal, but something in between. And so there are certain services that are devolved to the county governments, and therefore would be the county governments would need to be involved. There is the Judiciary Training Institute. There is the Immigration Service. There is the Ethics and Anti-Corruption Commission. There would be the Directorate of Criminal Investigations, which is a department or a directorate within the, but which has some quasi-independence. There is the Prerogative of Mercy Advisory Committee. There is the Office of the Attorney General. There would be also the National Commission, National Council on the Administration of Justice. I believe there may be a few that I may have left out, but the whole idea is just to oneself. This institution does it as representative as possible. Thank you.
Thank you very much, sir. Okay, no, Mr. Kimbola has another question to answer.
May I stand on all protocols so far established, and my due respect to the learned Silk who just presented papers. The first question I'm expected to respond to is on restorative justice in Lagos State. I remember in my presentation yesterday, I mentioned that that center is just a few weeks old. It has just been put in place pursuant the administration of criminal justice law. It's all part of the efforts geared towards making sure that this new law works effectively in Lagos. So on ground as we speak, that center is just setting up. No matters have been referred to it for now. It is domiciled in the Ministry of Justice. However, in practice, in our criminal jurisdiction in Lagos, I know for a fact that most of our criminal courts have, in part, been applying restorative justice. I can speak to a particular section in our criminal law, section 15 sub 2 of our criminal law in Lagos State, allows other dispensation measures for matters. Remember, we are dealing with criminal matters. So they often take recourse to restorative justice, reconciliation, restitution, and all the likes. Now, the new center that has been put in place in the Ministry of Justice is to serve as an alternative dispute resolution and a tool towards decongesting, to deal with less serious offenses in the courts. Your Honor will take note that most of the cases that come before the magistrates, in the largest part of it, they are simple, I could say even frivolous issues. Somebody stole a phone, Nokia 3310, offenses that will attract maybe 6 months, or even simple restitution, return the stuff, and then you go. So, in order to decongest the court dockets, matters would be referred to Restorative Justice Center. It does not replace the place of ADR at large. ADR is very, very effective. We have the multi-door and so many things that are doing real fantastic work in terms of restorative justice as well and ADR issues. So that is for restorative justice. The matter with respect to section 32, the right of suspect to be granted bail, and the scenario that Your Honor just presented, a matter had been in place, if I still get the facts straight, it has been in place, and then the ACGL now caught up with the case that lay prosecutors should not prosecute any longer, and it has gone far. I would not know how many witnesses the defense still want to call.
She said it's the last witness.
So I will want to believe that probably Your Honor would, after the last witness, the court will probably be ordering to file written addresses, and then the matter would be closed. For the fact that one lay prosecutor in a particular court has handed over the files, I would not expect that it's a big burden for the OC Lega who is expected. We had OC Lega here. The matter is more than 75% concluded. More than 90% concluded. I want to believe, sir, that will not, it will not kill the OC Lega who is a lawyer that can just tidy up that matter so that we can just have that one off the dockets. We cannot ask that matter should now start. In any case, Your Honor is still the court, the judge, the magistrate sitting on that case. The discretion of the court will play a lot on this matter. If a counsel is coming, a lawyer, police officer is coming into it, he might even decide a prosecutor is not bound to call, or whoever is conducting a case, you are not bound to call all the witnesses that you have listed for your case, whatever. So I want to believe that that's not an intractable issue. It can be dealt with, discretion of the court, and even the OC Lega can do something very serious to that matter. It can be sorted out. The third one, the issue of bail. Yes. Okay. The right of suspect to be granted bail, the practicability of it, and then what steps to take when defendants don't show up again. You are painting a situation that the defendant has been granted bail by the police. I'm happy that Leonard Silk yesterday informed the House that the issue of administrative bail, it does not come in place. It has been, the court has pronounced on that. So if the police is taking, or prior to now, granted anybody bail, like the courts will do, they are supposed to have reliable sureties who can be traced in the event that the real suspect absconds. I've handled a matter like that. The shorty stood at Zone 2 in Lagos. That's the force headquarters, Zone 2 in Lagos. And the suspect himself disappeared. Fortunately, they have proper documentation. I think the duty is on all parties. The police, who is using discretion to grant administrative bail. What we see in practice truly is they bring falsified documents in the court and they will just disappear. But in the hands of the police, I would not imagine that it is easy for them to escape, because the police would have traced people to their roots in the process of making arrest. So the details of that suspect will be very readily available to the, except the policeman is playing some games with the court. So administrative bail, the duty is on the police officer, the IPO, who in the first place granted bail. And in any case, somebody has to answer for a fake shorty that you admitted. For the police, they should call Osilega. Anybody that grants administrative bail in court without certifying, confirming the details of whoever stood, that person should answer for it in the office and possibly before the court. The courts always do due diligence when granting bail. I know some of our judges, you can bring a shorty 20 times, he will just be rejecting because it's not satisfied. Yes, it is allowed. So I think to make this law work for us, due diligence is required from all parts.
I think one of the concerns she's also mentioned, Honor mentioned, is that they are no longer, they said they send the file to the legal and they are not bringing the matters to court anymore.
Yes, the lay prosecutor sent the file.
Yes.
On the grounds that he's not a qualified lawyer.
Exactly. And they are no longer coming to court.
And then the defendant or the witness is not coming to court.
They're not bringing the matters to court. They're not.
Maybe we should clarify. Is it the witness or the complainant that is not coming any longer?
The essence of my question is, can the lay prosecutor arrange and then we give an order that after arraignment and grant of bail or consideration of bail, we order that the file be transmitted to the legal?
We do respect your honor, your worship here. For the purpose of arraignment, if it was to get a representation for the defendant, even in open court, my lord can ask any counsel to represent. But now it's for prosecution. It has to be the state counsel or police prosecutor. We do not need to stretch this matter too far. Other prosecutors who are lawyers can make out time if it is to arraign so that the suspect, the defendant, can be within the purview of the court for other purposes to be done. But if nothing has been done so far on that matter, nothing, my lord has not touched it at all. Your honor has not touched the case at all. Trial has not started, arraignment has not been done. What is the gravity of the alleged offense?
I think it's just the practice he's talking about. And I know the OC Liga was holding up his hand.
Maybe
I don't know whether you want to speak to this.
Matter,
yes.
If you are very
I think he wants to speak to it.
Good morning, all. My name is SP Achabo Kings, Osiliga Akwa State Police Command. As regards to what His Worship has said, you know, when this law came up, we were actually overwhelmed in the legal section of Akwa Ibom State Police Command. As I speak to you, there are just 7 lawyers in the command, and there are over 40 magistrate courts in Akwa Ibom State. So you could imagine the volume of work. When the files came, we had to start working on them. But of course, we were overwhelmed. So as I speak to you, I don't know the particular case you're making reference to. I know that some of us are handling those cases, but 95% of the cases that came to us have been transferred to the DPP. 95%. So I don't know if that particular case is with us or the DPP. I wouldn't know. But that is the situation now. For us to be able to work, we don't just do criminal matters alone. Civil matters are involved as well. So it's definitely not easy for us. We are coping. We are trying to get civilian lawyers as well to join us. We are making several other efforts to make it work. But for now, we are overwhelmed. And I'd like to use this opportunity to passionately appeal to the courts not to be too hasty in dismissing our cases because of the obvious problem this law has caused. They should give more time, afford us more time, give us more adjournments, and in time, I'm sure we'll get it right. Thank you.
I don't know about that. Hello, Chief Idigbe, do you want to say something to this?
My hand is up.
Okay. Yes, Milord wants to say something.
My name is Ntong Ntong. I want to say that no one will lie without first knowing the truth. No one lies without first knowing the truth. If you don't know the truth before you lie, or the person lies, not you, automatically the person will be misled or will mislead others. This law is curably defective. This law we are holding. They took so many things for granted. Arrangement and codification. Now, we don't want to say the story we know about this law. How this law was masqueraded, how it came to the public, and so on and so forth. Now, this law has created hardship, aggravated hardship to the courts. Behold, what my learned friend and wife said is clear. That if Section 491 was placed before, at the position of Section 490, and then the word notwithstanding anything, without prejudice, that any proceedings that had gone to advanced stage can be concluded upon the CPL, that would have been a good savings. So, and it is not given that a court of law should dwell or thrive on academic exercise. We are more pragmatic and practical. A court of law does not bother itself with issues that are not life issues. The answers given by my learned friend there, the only person that can give solution to the defects under the new system, that the court should not encapsulate itself by technicalities. Now we can make do with substantial justice. The chief judge of this state can cure the defects by practice direction. As my learned brother said yesterday, every other thing will amount to hearing and forgetting. I have held in one of my judgments that hearing and forgetting is equal to not hearing at all. The learned magistrate cannot proceed because CPL, under which she commenced, had been repealed. We are lawyers. Where the statement is unambiguous, you take it the way it is. The only saving grace is what my learned brother whispered to me, which is, continue. that we can proceed by inviting the pleasure of the Chief Judge to give us a practice direction. And the practice direction can guide the magistrates.
Exactly. In dealing with that
or
issue.
apply golden rule of interpretation so that the situation will not create more hardship.
Exactly.
That's my suggestion.
Thank you so much, my lord. I believe that is well taken. That is well taken, and that appears to be the right direction. Chief Idigbe, you were saying something.
I am Ezekiel Enang. Okay.
My lord is saying something. Please go ahead, sir.
Okay.
Please go ahead.
I want to refer us to section 49 sub 3. It reads, where there are no express provisions in this law, the court may apply any procedure that will meet the justice of the case. That said, they can now use this section to cure what is not provided in this new law. So they can continue with the hearing. Know what I'm saying? Where there are no express provisions in this law, the court may apply any procedure that will meet the justice of the case. Section 490 sub 3.
I'm not sure we can stretch that provision to cover that. And then, okay, please go ahead, Chief Idigbe. Yes, because we need to go to the next presentation. Thank you very much, sir. Thank you. I know we have more questions, but we are still going to come at this again. The last presentation we're going to be having is on case management, and it's going to be virtually. We're going to be listening to George Shelton from the USA. He's going to be telling us about their case management, and I think that is a very good time for us to bring together these thoughts that we have. If we take another question, another round of questions, well, Your Honor has been raising his hand. I know we have a lot, but it will delay us. Do you want us to go ahead with another round of questions? With another round of questions, maybe we'll take one more round. Okay, we'll take Milord and Your Honor at the back, yes.
If I may, thank you. Respectfully, all protocols observed. My concerns border on the comment that the learned speaker Silk had made, just the last comment, about the fact that it's about effective administration and case management. I'm concerned about who, when it comes to administration. The law provides for a monitoring committee. Many of us would have preferred that the committee would not just monitor, but be a committee that takes charge of the administration of the application of the law. The reason is this: the challenges that all of us would mention are institutional. We would probably, like in this case now, we're talking about the fact that police is not acting timeously. The police is saying that, oh, the DPP is holding on to all of this. The law itself seems to be dead on arrival, just like Milord had said, because of certain provisions that are made. It would have been beneficial if we had had a setup or a system in place that ensures that all the institutions that are necessary for the effective implementation of the law are already aware of what's supposed to be the case, so that we're not doing this reactively. Rather, we have a proactive situation that enables us to begin to have a synergy in what's going on. I have a concern about the fact that we tend to have individual view of how things are supposed to be done. My learned colleague was complaining about the challenge she's having with the case that was almost concluded. I appreciated the comment that the person from the Ministry of Justice, Lagos State, made about how that could be handled, and the admonition by the learned seal that we should be actively involved in case management. But sometimes it just goes beyond all of that, because you need to be careful that you don't do what might tend to be seen as you descending into the arena. So I'm concerned about who is the manager, who is the administrator, who is supposed to ensure that the institutions that are supposed to take charge and act before all of this are doing what they are supposed to do when they are supposed to do it. Okay.
So the question is, who is responsible for managing the cases?
Thank you. With due respect to me, lords, the participants and the facilitators, coming into force of the law presented some problems, but with the powers conferred on me, I devised a means which I want to share. Upon the detachment of the lay prosecutors, we had lawyers from the legal department coming to court and lawyers from the division of the Ministry of Justice coming to our courts. What I do is, when I receive a report from the lay prosecutor that the file has been forwarded to the legal department, I look at my cause list and know when a lawyer from the legal department is coming to my court before I sit. I now adjourn and order that that file, so transmitted to the police headquarters, be given to a particular lawyer coming to my court on a particular date for continuation of hearing. And I want to say that the legal department have complied with all my orders, and I commend them on that. So if we make orders, on specific prosecutors who are frequent in our court to handle matters investigated and prosecuted by their lay prosecutors, it will curb this problem that we seem to face daily. Thank you.
Thank you very much. I think that is in line with what Chief Idigbe said. Last question.
Thank you very much. I seek the consent of the organizers and the Chief Judge represented to digress. My digression is predicated on the fact that this talk shop is majorly an attempt to strive towards effective administration of criminal justice. The Constitution recognizes three distinct and independent arms of government. And the judiciary is basically to interpret the laws and come up with pronouncements that align with the facts and the law. I have something that has bothered me over time, and I want us to go home and ponder over this. What I will tag the executive review of judicial powers, which makes me most uncomfortable. A very ready example is where, after a court has handed down a sentence of death, for instance, it takes the activation of the executive powers by the governor to have the convicted person eventually sent to the other side of the world. That is clearly an act of the executive that is meant to review, meaning that it takes away the finality of the powers of the judiciary. As a judge for some years now, we deploy so many man-hours, judicial powers and time and resources to come up with pronouncements that only lay in abeyance, except and until there is is activated by the executive who, for instance, has to sign a death penalty or a death warrant. I want us to ponder, is it very necessary for we on the bench to spend sleepless nights and work from morning till night to arrive at pronouncements that never end up giving effects to, because of the need for ratification by another arm of government which is not involved? The Constitution does not give it any power, any role to play as far as the giving effect to judicial powers is involved. So let us ponder over this, whether it's actually necessary to make it mandatory for the executive to ratify an act, a concluded act of the judiciary. Thank you very much for permitting that digression.